to the Tower of Babel. He contended that in some areas, especially in Mount Kenya, public participation forms were faulty. There were incidents of pre-filled forms, and a vehicle ferrying pre-filled forms was torched in Nyeri County. That the National Assembly extended the exercise to the following day on the 5th of October 2024, but no proper notification was made and MPs kept away from the exercise. He added that in some constituencies like West Mugirango, the MP never opened the constituency office, and that the one center per county and one center per constituency is too deficient, as public participation should have been conducted at least at each polling station or at minimum each ward. Mr. Omoke submitted that the National Assembly neither processed nor considered the feedback collected, and the entire exercise was a mere sham to hoodwink innocent Kenyans. He accused Deputy Speaker Gladys Bos-Sholei of being biased in that on 23rd September 2024, while speaking at a function in Uasin Gishu County, she swore to spearhead the impeachment motion and put the Deputy President on notice, stating in quotes, "Mimi mwenyewe nitakupeleka nyumbani. In brackets, I will personally take you home." That she also hinted at some of the grounds of impeachment before the motion was even tabled. He further argued that Speaker Moses Masika Wetangula on 29 September 2024, while attending a church function at Wamonyo Catholic Church in Machakos County, publicly took a stand on the impeachment motion before it was tabled. Using the biblical description in Mark 9:38-50, he stated that H.E. Gachagua, being a part of the body that leads to sin, should be cut off. These utterances he submitted violated Articles 47, 50, and 150 of the Constitution, and that neither the Speaker nor the Deputy Speaker should have presided over the impeachment motion. Mr. Omoke submitted that the Constitution sets a high threshold for impeachment as a measure is a grossness of alleged violations, and that grudges and squabbles cannot be the basis for removal. He contended that extraneous grounds were introduced on the floor on 8th October 2024, as it was alleged that H.E. Gachagua had referred to Honorable Florence Jematea Sergon, the countrywoman rep of Baringo, as a harlot. That Honorable Karoli Omondi, MP Suba North, referred to conversations he had with H.E. Gachagua without providing any proof. Honorable Patrick Makau, MP Mavokis, to conversations without providing any proof. On the vote that 281 MPs supported the motion, 44 opposed, and there was one absentee, Mr. Omoke submitted that MPs abdicated their obligation to weigh the grounds against the intermediate standard of proof set by the Supreme Court in Odinga and 5 others versus IEBC and 3 others. That the impeachment overturned the decision of 7,176,141 Kenyans who voted for the joint ticket on 9th August 2022, a decision upheld by the Supreme Court, and that the motion was an egregious overthrow of the decision of the majority with that of a few. It was Mr. Omoke's further submission that no statutory legislation exists on the process of impeachment of the President and Deputy President from start to completion, as no legal framework exists on the collection of signatures in support of an impeachment motion. Therefore, there is no framework upon which the impeachment of the Deputy President was anchored. He submitted that in D and others, that is the Attorney General, this court was persuaded by Mr. Omoke, who was a petitioner therein, that the lack of legislation on signature collection and verification and on the conduct of referenda initiated the BBI process. He submitted that the same principle applies here, and that legislation is so central to the fairness of the process that the court ought to, at minimum, issue a structural edict requiring enactment of this legislation. He submitted that areas requiring legislation include initiation of the impeachment process, how Parliament is to process impeachment, particularly public participation, and the actual impeachment trial, the replacement of an impeached deputy president, provision for judicial intervention before an impeached president or deputy president is replaced, including grant of conservatory orders to preserve the rights of the impeached official, and expeditious hearing of petitions arising from an impeachment. Mr. Omoke saw no reason why the court could not have maintained the conservatory orders in favor of H.E. Gachagua and had the petitions within a week or two. That the discharge of the orders, followed by an immediate declaration of a public holiday for the swearing in of a new deputy president, left a mind-boggling question on the efficacy of Article 50 of the Constitution. For these reasons, Mr. Omoke prayed for a declaration that the impeachment of H.E. Gachagua was unconstitutional, and that a declaration that the absence of legislation operationalizing Article 150 of the Constitution rendered the impeachment process of the Deputy President flawed. We look at the 44th to 48th petitioner's case. Obuli Namenya, Kennedy Kareithi Gachagua, Dennis Okumu, Simon Mushangi, and Peter Maina Kanene jointly filed the petition dated 30th September 2024 before the High Court of Kenya at Nairobi. They describe themselves as Kenyan citizens committed to constitutionalism, the rule of law, and defense of the Constitution, and that they also instituted the petition in the public interest to challenge the proposed impeachment of H.E. Gachagua as Deputy Republic of Kenya. As per their petition and the supporting affidavit sworn by Obuli Namenya, the petitioners challenged the constitutionality of the impeachment process on the basis that Parliament had failed to establish a proper legal and procedural framework governing public participation in impeachment processes under Article 118 and 124 of the Constitution. The petitioners contended that neither the National Assembly standing orders nor the Senate standing orders provided mechanisms, procedures, threshold, timelines, verification methods, venues, or modalities for meaningful public participation in impeachment proceedings, thereby rendering contemplated impeachment process unconstitutional. They further argued that public participation was a mandatory constitutional prerequisite which ought to precede any impeachment process, and asserted that the 7-day timelines prescribed under Standing Orders 64 and 73 for disposal of impeachment proceedings were inadequate and unconstitutional, as they undermined effective public participation and violated the rights to fair administrative action and fair hearing under Articles 47 and 50 of the Constitution. The petitioners additionally allege politically motivated and tainted by bias and lack of impartiality on the part of parliamentary leadership, citing public pronouncements by parliamentary leaders in support of the impeachment motion. They advanced a historical argument concerning the office of the Vice President and Deputy President in Kenya, contending that successive deputy presidents had historically been subjected to political hostility, dismissals, and frustration, which informed the constitutional design of 2010, requiring the president and deputy president to be elected jointly. The petitioners then sought the following prayers: a declaration that the impeachment process of a deputy president is a sui generis in nature, and that public participation forms a fundamental background that plays a significant role in attaining the right to a fair trial enshrined under Article 50 of the Constitution. B, a declaration that public participation is the only avenue or means through which the people can exercise their sovereignty contemplated under Article 1 of the Constitution in determining whether an office created under the Constitution ought to be abolished, or whether accountability mechanisms created under this Constitution ought to be put in motion or otherwise, and that the lack of elaborate procedure or certainty as to when the same should commence or conducted will ordinarily amount to usurpation of the people's power and subsequently amount to a violation of the Constitution. C, a declaration that the Article 118 sub-Article 2 that clearly